Hi, welcome back to Terms and Conditions, the podcast by Maciel Carey. I am Letitia Silas. I am a traditional labor and employment attorney and partner in the Labor and Employment Practice Group at the Maciel Carey Law Firm. We are a nationwide law firm representing employers.
And I'm Samuel Rose, an associate at Maciel Carey, also in the Labor and Employment Group, representing employers nationwide.
Here on Terms and Conditions, we demystify workplace laws by discussing workplace issues in a grounded and accessible way to keep you informed as an employer of choice. Be sure to follow us on LinkedIn and on all platforms where you get your podcasts, such as Spotify, Apple, Amazon, and yes, iHeart. So today we are going to be discussing, in light of Valentine's Day, and I'm wearing my very special Valentine's Day sweater for everyone. We are going to be talking about workplace romance and what that means for you in your workplace. How does that sound to you, Sam?
That sounds great. I'm sorry I didn't wear my Valentine's Day attire, but I tried to find it and couldn't find it in the closet.
Well, I'll just wear all the love for everybody.
Perfect.
Okay. We forgive you. All right. So, Sam, why don't we just talk about whether or not there are any laws that prohibit workplace romances? So, are there laws on the books that prohibit consensual romantic relationships between adults in the workplace?
When I first saw this on our outline, Letitia, I freaked out because I thought you were testing me. And I thought that there might be a law that existed somewhere in the ether, and I went searching for it, and I came to the conclusion, as I thought, that there are no laws that cover that topic. It really is an unregulated, from a legislative standpoint, unregulated area of employment law.
So that's very interesting because many employers have policies that regulate workplace romantic relationships and dating in the workplace, in other words. And so, although there are no laws on the books that require employers to regulate this type of activity, why would an employer want to do so anyway?
So there's really a variety of reasons. There's legal reasons, there's operational reasons, there's social and cultural reasons. There's a lot of different reasons, and I think we'll cover each of these in the podcast today. But despite the fact that there is no legislation to that subject or on point, it's still a really important topic, and employers should take it very seriously.
Absolutely. So why don't we dive right into some of the legal risks and reasons why an employer would want to regulate romantic relationships or dating in the workplace?
That sounds great.
Let's start first with some of the civil and criminal liability exposure here. So on the civil side, I see perhaps sexual harassment claims or other types of legal actions, such as getting workplace restraining orders, which you're familiar with in California. Can you talk to us about that?
Yeah, so I think from the civil perspective, most of these are going to come up when that relationship goes bad, right? Like very similar to family law and divorce law and all those types of things. Nothing's really going to come up from an employment perspective if the relationship is going well. But if the people that are both employees or different levels, I won't assume that it is either one. If the relationship goes poorly, that could bring all kinds of potential civil liability. And I think the main one that you hit on is sexual harassment, which is a really important issue, a very difficult issue to navigate for employers, and one that can come up very frequently when a relationship goes bad. And whether there's, merit or whether it's used as a way for one partner to get back at the other partner, it brings up all kinds of issues for the employer that the employer has to work through. And like you said, the other issue is workplace violence, and that's sort of related to the sexual harassment issue, which is you could end up having an employee who feels threatened or feels like they are scared to come to work because their ex significant other is in their same office or in their same department. And if the employer feels like they have to step in and request a workplace violence restraining order in California, I'll speak to California because that's what I know best. it's the employer goes into court and requests that on behalf of the employee. And so now the employer has put itself in the middle of this relationship to try and protect its own employee, which it has an obligation to do, and now has potential civil liability on the sexual harassment perspective, and also has sort of taken on some burden or obligation in putting itself in this workplace violence restraining order situation.
Now, can individual employees in under that California law also get their own restraining order applicable to the workplace, or even maybe even labor unions?
So for workplace violence, they can't. My understanding is that for workplace violence, the employer gets it, but there are obviously criminal implications where if a employee files a complaint with a police department or some other agency, and the police department or a prosecuting office in the jurisdiction requests that restraining order via the criminal matter on behalf of the employee, that could cover the workplace. And that is another example of putting the employer in an operational bind, because now you have a restraining order against two employees who may or may not work in a close vicinity or in the same department.
Yeah, so when I think of not workplace relationships or workplace romance, I'm not only thinking of the romance that goes wrong, right? Things just go awry, and now you have two people who can't get along in the workplace, or you have some fear, or maybe just distractions overall in the workplace. But I'm also thinking about when there's flirtation going on in one direction, and it's really unwelcome. And because there isn't a policy in place, perhaps people believe that flirting, and where do we draw the line on that, right? Permissible flirting and impermissible flirting. If people believe that that's okay, they may engage in that type of conduct, but the person on the receiving end may feel that that type of conduct is unwanted and uncomfortable.
Absolutely. And that's going to probably result in some sort of HR complaint that the employer then is going to have to investigate, has a duty to investigate. And those can be very complicated cases for an employer to investigate, because you have basically an employee's word against another employee's word. Sometimes you'll have third-party witnesses that can help kind of provide context as to what kind of dynamic there is between this relationship. But very often it's going to be two people making allegations against each other, and the employer has to somehow, and it's a very difficult position to be in, parse through those allegations and figure out who's more credible, which allegation is more credible. Is there any evidence or documents or any type of evidence to support these allegations one way or the other?
I'm even thinking about when, on the criminal end, when perhaps we have many generations in a single workforce, including teenage workers who may just be working over the summer, and someone is 17 or 16 or whatever the threshold age is in your state, but they are below the lawful age to be involved in an intimate relationship with someone who's an adult, right? We have that dynamic now. And so if that line is being crossed, then there's the potential for some criminal exposure in terms of the employee involved, the older employee. And I also think that we need to clarify that we're not just talking about, a certain type of individuals that when we think of relationships, we ordinarily see this type of a person and that type of person. This is all types of romantic relationships, both sides, right? So I just want to keep that in mind, because I think sometimes there is the misunderstanding that if the romance doesn't appear in a way that we understand or we imagine a romance to be, then then the rules don't apply, or we don't need a rule on that. But the truth is that if there's this vulnerability in the civil or criminal space, we need to be regulating that.
Absolutely. And I think to that point, I mentioned at the beginning, the cultural aspects of this topic. There are cultural differences in how people interact in either friendship, relationship, romantic relationship. And if the employer doesn't have a policy that's applied uniformly, or doesn't understand different cultures that it may have within its organization, the policy could either be over inclusive or under inclusive and may not actually be accomplishing what they think that it's accomplishing.
Absolutely. Let's talk about other risks in the workplace that maybe there's no violation of law. Maybe there isn't any civil or criminal exposure here, but maybe there is a risk to just the overall workplace morale, workplace dynamics. What are your thoughts on that, Sam?
I think this is an issue that comes up in almost every issue we advise employers on, and I'm sure you've seen this too. Very often there's not a law that's being violated. There's not a legal principle that has to be applied to a certain situation. Oftentimes it's just, do we want to have this policy to maintain the morale or the perception that to our employees that we care about them, that we are protecting them, that they are important to our organization. And oftentimes when there is no law on point, like there isn't in this case, it's really about navigating what position does the employer want to take in this topic? What message does it want to send to its employees? And how is the policy that we've decided to implement furthering those goals? It's very often a business decision and not really a legal decision. So I think that's a very big part of very often what an employer is considering when it implements new policies, especially in this area.
I also think being aware of those power dynamics in the workplace that impact morale and the different types of romantic or dating relationships that could crop up that would impact that, and that we need to be thinking about that along the lines of supervisor subordinate relationships, adult teen, which we talked about a moment ago, the older adult to the younger adult, even though they're both adults, maybe there's still that power dynamic in terms of ranking within the organization, economic status, and maybe even in terms of different genders there, or same gender, just in terms of the culture of the organization overall, how the power dynamics are situated. These types of relationships could impact that.
Absolutely. And I think those power dynamics and those potential um, hierarchy of the organization, that does have potential legal implications. I know in California, supervisor, subordinate sexual harassment liability is a huge issue. And the courts have said that if an employer, if a supervisor does engage in sexual harassment of a subordinate, the employer is liable for that. And that is an example of an area where you will want to have a policy, because that is an area of this issue that is governed by law, case law in this case, not necessarily statutory, although it comes from the FIHA, which is a statutory ban on discrimination. But you wouldn't know that automatically just by reading the statute. And so, although we look at it as potentially more of a morale issue, that component is very much a legal issue and a very huge potential liability for an employer.
Oh, that's a great point. That's a great point. And absolutely, that power dynamic between superior and subordinate, even if the individuals involved don't believe that that imbalance in power will impact their relationship or even the workplace culture, it could impact people around them, right, who see it and perceive it in a certain way. So it's not only actual, it's also perceived, in my view. What are your thoughts on that?
Absolutely. I mean, from a third party perspective, and I'll say third party to mean the people that are not involved in the actual relationship, especially if it's a supervisor employee dynamic, it could have the perception that someone's getting favoritism, that someone's getting work because they are in a relationship with someone. And that can absolutely harm the morale of your organization. If people don't feel like they're valued, if people don't feel like they're going to get the tasks and assignments that they need to further their professional development because someone else is in a romantic relationship with the boss, that's not a dynamic you really want to have. And you really want to avoid that in order to keep your employees happy and keep their morale up and keep them motivated to work for you.
Right. And you don't want to have an environment where the rumor is, the water cooler conversation is that the reason why so and so got this promotion is because they are in a romantic relationship with the boss. You
Exactly.
don't want to have that rumor mill going or that water cooler conversation, because then other people will believe that, well, it's not based on merit, it's based on a special, not only special, but an intimate relationship with a superior. And what message does that send? Um, so, Sam, let's dive in now to some of the rules or policies that employers might want to put in place to effectively manage these types of relationships in the workplace.
Yeah, I think the main one that you're going to see and that employers will often consider implementing is a sort of socialization or fraternization policy where they will just prohibit certain types of relationships. And if an employer doesn't want to flat out prohibit it, oftentimes you'll see them say these are not permitted unless it's disclosed to HR or disclosed to someone higher up so that they're aware of that dynamic. It's an important dynamic that upper management be aware of, because if you are making, for example, as we just talked about, promotion decisions or um, raised or awards, whatever you want to call it.
Terms and conditions of employment.
Terms and conditions. Exactly. Exactly. Even if it's not the main reason why it's happening, if it's perceived as that, that's a problem. And upper management can't avoid that perception if they don't know about it. And so I think that's the main policy that employers will implement. But I'm curious if there's others that you have seen implemented by employers besides that.
Well, I think just starting first with the basics. You want a anti-harassment policy. You want
Totally.
a policy that is clear that sexual harassment of all kinds is unwelcome, not will not be tolerated, and will be disciplined. Right. So you want to make that crystal clear. On top of talking about that policy or having a policy in the handbook, I think we need to be training people in that policy. And I think that in addition to the training, and I've attended lots of trainings, but how many trainings have you attended, Sam, where they actually talked about romantic relationships in the workplace?
Well, in California, we have required sexual harassment training. It's annual for employees, and it's not explicit, but it's definitely implied that these romantic relationships are covered by the policy. I would agree, though. I think it's better to be very explicit so there's no gray area for employees to misinterpret or misapply your policy to their own romantic relationships.
Absolutely. I've done and I've watched, I've sat in on as an employee. I've been, I've had to receive sexual harassment training, but it is rare that the training deals specifically with the policy governing workplace romantic relationships or dating in the workplace. And I think that that is perhaps an area where an employer might want to include that topic in particular in the types of trainings that they do in just overall workplace conduct along with those anti-harassment. So I'll say that like you said, some employers may have a policy where it's just outright prohibited, right? Dating in the workplace, dating a coworker, dating a boss or subordinate, just automatically prohibited per se, right? Can't do it. Then there are some policies that I've seen where the employer says, well, we don't permit superior to subordinate relationships, supervisor to support subordinate relationships, but all other relationships are unregulated, right? And or they are, although they are unregulated, perhaps there just needs to be a disclosure and a sort of a sign off saying that I recognize that I'm in a romantic relationship at work. I've seen that. I also think a workplace bullying policy could be applicable here. You want to make sure you have that in place and include examples or types of provisions that involve a dating scenario or things that could come up when individuals are dating or experiencing a breakup. And also a social media policy that talks about what you're posting in terms of that relationship, because what people, the images that people post, the comments that people post, that could all come into play here in those types of relationships.
Absolutely. Yeah. I think those are all great policies that employers should consider. I also think it's really important, and I think this goes hand in hand with what you mentioned about training, is just ensuring that employees know how to report sexual harassment, how to report any perception that they have. Feel you want to make it feel like you have an open door policy, right? It's better that you know things and that you can help resolve them than to just be in the dark and later on you get a failure to prevent discrimination or failure to prevent sexual harassment. And those are all potential, going back to the beginning, all potential civil liability for the employer. And so if you can ensure that everyone knows what they're supposed to do in the event they experience sexual harassment or a potential breakup, or who to report that they have entered a romantic relationship with, that's a really important aspect to all the policies that you've mentioned.
Absolutely. And not only making sure that the employees or the staff know what to do, or management, but also the administrators in HR, that they know what to do, that they know the steps to take, that they know how to conduct an appropriate investigation, that they know how to even handedly and consistently apply policies, that they know how to counsel individuals when it is necessary and to take the appropriate corrective actions when necessary. So, Sam, let's dive in now to what some of the key components of a policy might include. So, in my view, let's just start with the scope. If you're going to draft up a policy, I think you have to start with defining the scope of the policy. Like, what is the type of conduct that we are trying to address in this policy?
Yeah, I think you can. This is where it comes into how you want the message to be sent to your employees, right? You can have a very narrow scope that this is just governing romantic relationships in the workplace, or you can have a broader scope, right? Like your anti-harassment policy is going to be much broader than that. It covers way more than just a romantic relationship. But it's really going to be, what policies do you have underneath this one, and how do you want them to apply to your workforce? Do you want it to be generally applied, or you want it to be narrowly and specifically applied?
Yeah, so let's suppose that the employer has an anti-harassment policy, because most of them do. They have an anti-sexual harassment policy. And now, after watching the Con Macio Carey or listening to the Con Macio Carey podcast, they now think, you know what? We ought to have a policy that speaks to these romantic relationships and dating in the workplace, because maybe we've seen a few things and we haven't known how to deal with it. And now we need to develop a policy. So we want to start with the scope. First, make it clear that you are talking about workplace relationships, even if they are consensual, right? And you want to give the why, the what, and the why for the policy, why this is important. And then, Sam, what are your thoughts on defining certain terms so that everybody is clear?
Yeah, I think it's very important from a liability perspective to define them, because when you cite to this policy in your answer or later on in discovery and in a civil lawsuit, if there is potentially one, that's obviously very important. I tend to think that employees don't really pay attention to what the definitions are in the policies. So I don't know that if it's in your handbook, that it's enough. I think, like you mentioned earlier, it needs to be in the training. It needs to be reinforced in refresher training. It needs to be reinforced at every step that the employer can do it, because you can't just rely on one policy in one place and assume that that's going to be an effective way of preventing any of this type of conduct.
I absolutely agree. And I think that in most cases, people don't go looking for the employee handbook or the policy until there's something wrong. So you have to be able to get the information to the employee population in a way that they can receive it, and that is not burdensome, that it doesn't require them to read 5 pages, that you can get it to them quickly in a way that they understand and can relate to. And a great way to do that is through training, actual in person or virtual training.
Absolutely. And even having, I oftentimes I'll see like you said, a scope. So the beginning of the policy will be the scope. The second paragraph of the policy will be a synopsis. Basically, what is the like too long didn't read version of this policy, so that at least you've given your employees an accessible version of maybe a policy that could be 1 or 2 pages long, right? And of course, you're going to require when you onboard someone, you're going to require that they read the whole handbook, and you're going to require that they read your sexual harassment policy or anti-harassment policy. But with the knowledge that very often they won't do that, if you have a little synopsis at the top, at least you know you've covered the very basics, and you can build on that in your refresher training or in your annual sexual harassment training.
Absolutely. And going back to those definitions, defining what a subordinate supervisory relationship looks like, right? If there's someone who reports directly to you in your department, or is it company wide? Like defining what the parameters are in terms of the relationships that are permissible or impermissible. What about specifically laying out the restrictions and prohibitions? So we have our scope, we have our synopsis, we have our why, which is probably in the synopsis somewhere. We have our definitions. Now, what about being very clear about what the prohibitions are and what the restrictions are?
Yeah, I mean it's extremely important to be clear, because if it's not, then you're opening yourself up to the fact that your policy is vague or it doesn't make sense, and the employees don't know what they're supposed to be doing or what they're supposed to not be doing. So making it clear is very important, and I think a big part of that, and you'll often see this with employers who use attorneys to draft their policies, right, is not using legalese in these policies. Don't make them super complicated with like extremely big words that no one understands, because they're pulled from a case law that was issued in like 1985. It's not helpful. Your employees just want to know, what am I allowed to do? What am I not allowed to do? Put that in plain language and make it very clear what your expectations are of your employees.
Absolutely. I've even seen policies where there's an example, like the prohibition may be there, and then there's, for example, something that looks like this would violate this rule. I know you can't do that for every single bullet point, but I have seen that done effectively. What about reporting resources in the policy itself, like giving employees direction in terms of where they can report concerns or violations, or even pose questions?
Yeah, I think not including that in the policy is a really bad idea. It should absolutely have a reporting structure. It should absolutely have a phone number or an email address if you have a centralized HR department. If you're a bigger organization where you have different HR personnel assigned to different departments or to different employees, even on a more specific level, making it very clear that who that person is in your training, so that every employee knows if they need to report something, who they can go to, and making sure that the policy reflects that, whether it's general, like you have an HR inbox that you just send it to and it gets processed, or it's a specific person, making sure that specific person is listed in the policy. The only caveat is, obviously, if that person ever leaves or is separated from the organization, you have to make sure that you update that policy, because if the person who is listed in the policy doesn't exist, that's going to be a huge problem and open you up to potentially big civil liability later on.
Absolutely. I've even seen policies where maybe it's not a specific name, but it's a classification or role that employees should report to, but that position has been vacant for months, sometimes longer than months. And so what does that mean? Does that mean you really have a policy, or you just have a policy in form and not substance, because the individual or the position that is charged with receiving complaints or answering questions has been vacant for quite some time? So you want to make sure, like Sam said, that you are keeping on top of that and making the adjustments as appropriate. Sam, now let's just suppose that an employer finds itself in this quandary, and there are these relationships in the workplace, and it's been going on, but now they just heard the CMC podcast and they want to do something about it. Now, we're not here giving legal advice. You got to call us and talk to us, and we have to have a relationship for that. So, this is not legal advice, but generally speaking, what are some of the actions that employers could consider?
Well, the first one that you should consider is calling Letitia or I and having us help you out with that. I think it's from my experience, it is very important that an attorney, whether that's in-house counsel or outside counsel, is involved from the beginning, because I think very often the HR generalists know what their role is as an HR generalist, but they're not looking at the bigger picture about potential civil liability, about operational efficiency, about how this department is going to work going forward, about how the investigation could potentially impact the company's morale or the company's ability to operate in that department. And so having a broader picture and someone who's not so ingrained into your organization is extremely important. If you're not going to do that, it's not the end of the world, but you want to make sure that you have a very rock solid investigation. If you are equally applying your policy, that there's not some relationships that you're saying, ooh, we feel uncomfortable with that, but this other relationship we're allowing. That could potentially open you up to a discrimination lawsuit. There's a lot of ways that this could grow into something much larger than just, a violation of our fraternization policy or a violation of our romantic relationship policy. It very quickly can spiral out of control, especially if people start separating, if people start talking, if people start spreading rumors, and now all of a sudden no one even knows what the facts are.
Absolutely. And you want to engage counsel, I think, because number one, you want to have some privilege around some of this, all these discussions that you're having and all the investigation itself. You want to have some legal guidance on what to do when the types of questions you should be asking, the type of information you should be looking for. I also think that legal counsel on the outside can be very helpful to pointing out sort of I call it the where's Waldo. Sometimes you've been looking at it so long that you don't see it, right? But somebody from the outside looking in with a fresh pair of eyes, they go right to it and they're going, well, this sticks out to me like a sore thumb, right? And so maybe you want to pay attention to that. And that could especially be true when we're talking about a potential bias, right? And maybe there's somebody on the outside looking in with a fresh pair of eyes that can advise. Sam, I also think as in-house counsel, and I've been in-house counsel, it's helpful to have outside counsel to be a strategic thought partner with. Like sometimes you need that because all of the information within your organization, perhaps there's a culture of we've always done it this way or we've never paid attention to that. And so you need that strategic thought partner and legal advisor outside of the organization, even if you are an attorney that's in-house.
Absolutely. I think that's a great point. And I also think that outside counsel can be important if the investigation involves interesting dynamics. Like, for example, if the general counsel or an HR generalist or an HR manager is the one who is involved in the romantic relationship, hopefully you don't have that, because if it's a violation of your policy and your HR or GC is violating the policy, that's a big problem. But it also could be a way of invalidating the investigation. If the investigation is being done by a person who either knows someone who's involved in the romantic relationship or is involved in the romantic relationship, that's not a good investigation. It's going to lead to all sorts of problems down the line.
That is a key point. Sometimes an employer might, or an organization might have the circumstance where those involved are very senior level individuals, including those at, I would say, the highest rank in the C suite. And so you want to have your outside counsel assist with that because you want to have that objectivity and you want people to be able to participate and cooperate in the investigation without fear of disclosure of their statements potentially or some sort of retribution. And the way that you could put some guardrails around that and provide reassurance to people is by having an outside attorney conduct that investigation.
Absolutely.
All right. So, other than hiring me and you, we went on for a long time. What else can employers do? We talked about having a policy. We talked about training. What about reassignment and recusals? Sam, can you talk a little bit about that?
Yeah, I think reassignment it's an interesting option. It's definitely one that employers should consider. I would just caution that it needs to be done in the right way, right? If it's perceived as changing someone's job duties or discriminating against someone and moving them to a different department on the basis of something other than violation of a policy, you're going to get yourself into a little bit of an issue there potentially. And so anytime you're moving someone from one place to another that isn't up, right, then you're potentially opening yourself up to some issues down the line. And so you want to make sure that a reassignment is really carefully thought out, really carefully planned, and really thought through.
100%. And you want to be careful that you're not moving a problem from one part of your organization to the other.
Right.
So, supervisor was in department A having inappropriate relationships, even if they were consensual, right? If it violates company policy or there's a perceived bias, that is likely inappropriate, I will venture to say. And then you move supervisor to department C and they do the same thing. So, that reassignment, you really have to be thinking about, are you just spreading a problem? Or is this a situation where maybe there needs to be some sort of leave pending investigation so you can look into this and then determine whether a reassignment would be appropriate in these circumstances?
Yeah, and I was just about to say the leave pending the investigation. But from your perspective, right, if the CBA governs administrative leave or leave pending an investigation, and you have that in a contract, you have to follow it. There's no option, right? It's a binding term on the employer and on the union, and you have no choice but to go down that route. And so make sure you're following your policies, you're following any potential CBAs, and you're not violating either one, because that's another avenue of potential liability. All kinds of potential liability all over the place.
And every time I talk to an employment lawyer, they make me put on my labor hat. And I have to point out, folks, that just because it's not in the CBA doesn't mean that the rule doesn't apply.
Right.
Sometimes something is not written in a CBA, but maybe it's in your handbook and the handbook applies because it doesn't contradict the CBA. Or maybe sometimes you have an established past practice of putting people out on leave under certain circumstances, and you should be following that because it is as if it is written in the CBA itself. And so that's why you need to call me to understand the legal definition of a established past practice under labor law. But generally speaking, yes, Sam is correct, but it's not so simple.
Yeah, and I think there's all kinds of potential pitfalls here, and that's why I think it's so important that you contact some sort of counsel, whether it's your in-house or outside counsel, because even the act of putting someone on leave, right? If it's not in your CBA, and like you said, you're doing it based on past practice, but it turns out that you've only done it for women, or you've only done it for a certain race, or you've only done it for only people with disabilities, right? Now you're opening yourself up to a huge discrimination lawsuit. Not only are you maybe failing to prevent sexual harassment, failing to prevent discrimination, but now you're actually affirmatively doing it. And that's where this whole thing can go really awry.
Or just to go off of that, right? Or if the offender is female and the I would say the target, because I don't know what else to say at this point, is the complainant is male,
Mm-hmm.
but you don't take it serious because you don't see the power dynamic that way. That's problematic. Or let's just suppose they are of the same sex. Same rules apply, folks. Doesn't matter. So, same rules apply, and you need outside counsel sometimes to help you see that. All right. So, Sam, and in terms of things employers could consider, finally, I have some sort of counseling or discipline because sometimes it rises to that level.
Yeah, I mean, anytime you have any violations, well, we'll take this topic because that's what we're talking about today. But any violation of any company policy, you absolutely want to document that. You absolutely want to put a note in there in an HR file, because down the line, if something else comes up and you can't show that there was all these documentations, then you're really at a disadvantage when it comes to any potential either civil lawsuit or arbitration, right? A charge from a union, or if you want to take the labor, you want to take the employment side. It goes both ways. You need to have everything documented, um, and it helps you, right? Like if you tell someone maybe they truly, genuinely didn't realize what they were doing was a violation of the policy, and just that documentation or that refresher training shows them what the policy is and how they should be conducting themselves in the future. That helps you as an employer. Now people know what they need to be doing and what they shouldn't be doing, and ultimately that's what we really want, right?
Absolutely. Absolutely. Okay, Sam, I think we have fully explored this topic and given our audience some helpful tips. Thank you, everyone, for tuning in to another episode of Terms and Conditions, a podcast by Con Macio Carey. I'm Letitia Silas.
I'm Samuel Rose.
And until next time, stay ready.
So you don't have to get ready.
That's right. Bye bye.